Hello, everyone. This is Tom Fox back again with Matt Kelly for another episode of the award-winning Compliance Into the Weeds. Welcome back, Matt.
Hey, Tom, good to be here.
Matt, we continue our never-ending saga involving the Boeing company. And today I want to take up the proposed plea agreement that has been filed jointly by the Department of Justice and Boeing in the federal district court. You want to take it from there?
Sure. This is the plea agreement, which had been coming, and we all knew that for a while, and we knew the broad contours of it, which are Boeing pleads guilty, 3-year probation agreement, compliance monitor, $243 million criminal penalty, which is the same amount it had to pay for a criminal penalty for its original DPA back in 2021, that it has now been found to be in violation of, and then $455 million in compliance program improvements over the next 3 years. I'm curious where that rather precise number came from. Not entirely clear on that. But anyways, we had all of that. Still needs court approval. The families of the victims of the two plane crashes in the late 2010s that brought us to this point, those families are still saying no, the judge in question here should not accept this plea agreement. And I wouldn't be sure exactly what else would happen after that. But it looks like this is going to be a done deal. But for all of those headline things, I put those aside because we've seen that for a while. Now that we actually have the text of the agreement, I was looking more at exactly what did Boeing do wrong during its DPA that led prosecutors to say, no, you violated it. What did that look like? And then number two, what is Boeing supposed to do now to improve its culture of compliance? Because that was also part of the 2021 DPA, and the culture didn't improve enough. So there are new steps that they must take now. And I've been going through looking only at that, but I'm sure there are plenty of other issues that you have on your mind or other listeners do, and we could discuss this for days if we want.
Matt, the thing that intrigued me, or one of the things that intrigued me that you hit on, is that there seems to be a confluence of several different areas or topics that perhaps you and I had not traditionally considered compliance topics. So fraud or anti-fraud, safety, and concerns. So one of the things that struck me in reading this is the DOJ trying to ram into either a compliance monitor, a compliance function, or the compliance language from the original DPA, things that have traditionally been outside of compliance? Or maybe I should flip it and ask, is this an expansion of the corporate compliance role?
I think it kind of gets to that, yes, because I can tell you very specifically, just before we got on to the record the podcast here, I was looking at attachment C of the plea agreement, which lists all of the compliance program improvements Boeing's supposed to make. So here I think is the nut paragraph that this is what prosecutors ultimately want Boeing to achieve is, quote, a commitment by the company to the integration of its ethics and compliance program with its safety and quality programs for the purpose of deferring violations of anti-fraud laws or policies. Close quote. It really gets to what I think is the point here is that Boeing needs to treat safety and product quality shortcomings, which I think have largely been driven by the company's pressure on employees to hit financial performance goals and market share and whatnot, but treat product quality and safety issues as fraud. And therefore, if your culture of ethics and compliance is about not committing fraud, that would also imply that these safety shortcuts and product quality shortcomings that exist within Boeing, which are essentially a fraud on the consuming public, because when we get on a Boeing plane, we do not expect it to fall out of the sky or have a door blow off mid-flight. All of that, therefore, is also an ethics and compliance concern. And that's really what we want to achieve. I think the way that I had described it was that really ethics and compliance and safety, where did I say it? They're like two sides of the same coin that Boeing is supposed to remove from circulation. So does this mean that its chief compliance officer will now report into the head of anti-fraud or vice versa? I don't know. I'm not really sure on that. But I do think that this is going to result in a long rethink of Boeing's anti-fraud policies. The plea agreement talks about how it has to adopt written anti-fraud policies that somehow encompass safety and product quality risks. And when you think about what does that really mean in aircraft manufacture, extensive attention to documentation, because every single step of airplane manufacture is supposed to be recorded, stamped, to use the phrase within the industry. All of these records are supposed to be readily available so that if there is an issue, it can be identified, that Boeing could then talk about it with its manufacturing suppliers who might have made a defective part, or its airline customers who might have bought a questionable plane, with safety regulators, then especially the Federal Aviation Administration. So there's a lot here that Boeing has to do, but at the root of it all is treating product and safety issues as a fraud risk that must be addressed in its culture of compliance. And there are some other more specific details later on, but I think that's the high level of what they're trying to get at here.
So, Matt, I'd like to maybe turn to a different set of topics, and that's the monitor, oversight of the monitor, the required compliance or other spend, and then how the victims' families were treated in this document. With regard to the monitorship, the proposal is that and I'm just going to quote from the plea agreement, the condition of probation is limited to the retention of the compliance monitor, not the oversight of the independent compliance monitor or the company's compliance with the independent monitor's recommendations. On part one of that, which is the retention of the monitor, that seems to limit, or rather, Boeing and the DOJ are trying to limit the court's role as to approving the retention of the independent monitor and not the oversight of the independent compliance monitor. But equally troubling to me is that it's not a condition of probation that the company comply with the independent monitor's recommendations. And that would seem to me, number one, to completely defang the independent compliance monitor if Boeing, even at this point, can complete its probation without having complied with what the monitor has to say in the way of recommendations. The second is safety and compliance investment, where there is a dollar figure of 455 million, representing an average annual basis increase of approximately 75% above the defendant's previously planned expenditures on its compliance program for fiscal 2024. Elsewhere in this plea agreement, the parties and Boeing and the Department of Justice aver that the compliance program, or Boeing met the obligation for a compliance program. What it didn't meet was the obligations to test that. Now, I know you've picked out many examples where there was a failure of this, but I find obviously that's a lot of money, but is that really going to be enough? Either one, get it done or satisfy the various stakeholders here. And then the last one, which I have to wonder where this came from, is the meeting between the board of directors and the crash family victims. And there's some great specificity in this paragraph. One, it is an in-person meeting that 80% of the board members must attend unless they live outside the United States. Then they can attend by Zoom. It must occur 4 months after the defendant is sentenced. The defendants, Boeing, has to arrange and pay for translators in a variety of languages. And the purpose of the meeting is to hear from the crash victims' families about the impact of the defendant's conduct, one, and two, the crash victims' families' recommendations for the defendant to improve its compliance, safety, and quality programs. Not institute, not accept, but simply hear. I can't imagine the victims' families would be satisfied with this. Number one, there's, of course, no provision for payment of their transportation or accommodations. I can't see that anything will come out of this because other than the board members having a very uncomfortable day listening to the victims, families of the victims talk about how Boeing's negligence has directly impacted their lives, they don't have to do anything. And that really leads to another observation that there is nothing about the board's role in any of this. The Delaware Court of Chancery skewered Boeing in their review of Boeing in its violation of its Caremark duties. So I knew I threw a lot out there. Any thoughts on any of those three provisions?
I'll try and take them in turn. On the compliance monitor, and I think ultimately the goal of that arrangement was to make sure that a federal judge doesn't wade into this case because this is a big, terrible, tragic case. And I think a lot of federal judges would have a lot to say. And I don't think the Justice Department wants that. That's pretty much it. And let's also remember that for most corporate criminal settlements, that is routine, is that the department and the company in question reach a settlement and the judge reaches for his or her rubber stamp and then it's done. I think that this is very rare that you would see a judge get activist. And when judges have tried to do that in the past and the department and companies have taken them to task, judges have been overruled for being too bold or rejecting a plea agreement. And I can see why the department wants to minimize the risk of this external element of a federal judge getting involved. So, sure, in that case, the monitor has findings that he or she will report to the department rather than the court. Is that right or wrong? Like, I don't know. I'm not entirely sure, although I can see the Justice Department's perspective that it would prefer to have it maintain control over this case in the terms of settlement, not a federal judge rule it out of order. That kind of gets to, I suppose I'll take these out of order then. The victim meeting with the board, I didn't know the details of it, Tom, until you described them all, but really it sounds to me almost like a victim impact statement. If this was an actual criminal trial and there was a judge overhearing this, that's the sort of thing that you would expect to see in a trial. Now, Boeing doesn't want a trial. I don't think the Justice Department wants a trial either. And so, therefore, how could they get to a victim impact statement kind of event? Why don't we tell the board that you're going to have to show up and do this? I do know that the victims' families are not at all pleased with this. They would like to see the judge reject this plea agreement. They would like to see individual executives at Boeing held accountable, as in criminal trials for these people. I am deeply sympathetic to them. They suffered the heaviest price out of everybody here when they had loss of loved ones. But I do think that what's the point of that victim meeting? I think the point is to try to avoid a judge deciding, no, we're going to have a big, huge formal hearing. The department doesn't want that. Boeing certainly does not want that. So this seems like their idea of a stopgap measure or some sort of make good for the lack of a victim impact statement. In theory, you talked about what is the board's role in all this. This is one thing that the compliance program is supposed to do, according to that attachment C that lists everything out. Of course, the first thing is a commitment to compliance, which we always see in every attachment C that I have read for every criminal case. But it does say that the commitment is supposed to happen where senior management and the board, quote, must provide strong, explicit, and visible support and commitment to compliance and demonstrate rigorous support for compliance principles via their actions and words, close quote. So the board is supposed to do that. I don't know what that's going to look like in practice over the next 3 years, but at least in theory, the agreement does have a nodding acknowledgement that the board should be doing more here, and I think it should. And Tom, to your last point about the $455 million in enhanced compliance spending, I haven't read through all the details of the plea agreement yet, so I didn't know it was 75% over the average annual spend before that. But one question I would have is, how are we defining what compliance spending is if compliance is supposed to have, I don't know if it's a merger or a takeover of fraud and safety and product quality risks, but if compliance is going to be doing more that might have been run by other functions in the past, would this mean that those functions still get their same budget and then there's more compliance spending? Or are they shuffling that spend from those other functions into compliance? So their spending must therefore go up. And does that count toward the increase? I would be curious to know what the answer to that question is. But I think, like I said before, we could talk about this for many days and maybe we will. But that was another point that jumped out to me as you were describing how we define what the enhanced compliance spending is.
Matt, I think this is something we are probably going to have the opportunity to revisit in the future. Can I ask if you're going to be writing about this?
I will have a blog post up shortly about just really what is in attachment C at the moment. The first few episode points about what the compliance program is supposed to do. And in fact, while I'm here, Tom, I will give out a shout out for one pet question of mine I've had for this whole ordeal. There is also an attachment F, which is the compliance officer certification. That's now going to be required as part of this plea agreement. That was not required in the original DPA from 2021, which was hatched before CCO certification of the program became a thing. That didn't become a thing until 2022. So I still am wondering, what risk does this bring to the chief compliance officer at Boeing now when clearly the company already had compliance program improvements it was supposed to make and it didn't? And now they're supposed to make more improvements. What if they don't? Will this, therefore, what sort of exposure will that bring to the CCO at that point in the future, which should be, what, 3 years from now in 2027? Who is that compliance officer going to be? What will he or she have to commit to? What will the CEO at the time also have to commit to? Because they co signed together on that. I'm not entirely convinced that we'll have the same CEO at Boeing in 3 years, anyways. We seem to have a rotating number of them because Boeing is a lot of trouble. So that is yet another issue that we need to consider is CCO, CEO certification of the compliance program when you have these especially long, drawn out, messy sagas of compliance programs not working. Think about that too.
Think about that and look forward to seeing your thoughts on that in print and hopefully talking about it in an upcoming podcast.
Thank you, Tom.